On this morning's docket, case number 107422, State of Kansas v. Funk.
Please the court, the Gerald E. Wells representing the defendant in this matter, appellant. I would request 3 minutes, please, Chief Justice, for rebuttal.
3 minutes is granted.
In my argument, I would like to focus on the so-called first factor of the three-factor Freeman case, which is what we use to decide whether or not there has been a cruel and unusual punishment violation. I would like to further focus on the first factor, which I won't repeat in its entirety, but surrounds the nature of the offense, character of the offender, with particular regard to the danger present to society from that individual. And I think the facts of this case are particularly important because I'm going to advocate to this court that the facts are so grossly disproportional to the lifetime post-conviction period that it overshadows, as Freeman says it can, all the remaining two factors, which are comparison tests of state laws and then out-of-state laws dealing with this particular subject matter and others. I think the facts are, if not in some ways bizarre, are certainly, and the Court of Appeals panel concedes this, that there were a number, and we think all factors, that weighed in favor of this appellant. First of all, this appellant was convicted of a level 8 felony when he was originally charged with a 3. He was 19 years old at the time. The so-called victim was 16, or so she told him at the time. And I think it's very important also to note that he did not instigate any sexual contact, nor was he the aggressor, nor did he ply her with liquor or anything else in order to get her to comply with any sexual contact. So from that standpoint, any way you look at this, those particular factors not only weigh heavily in his favor, but are also a basis for gross disproportionality in terms of the eventual punishment. Now, the Court of Appeals...
Can you just clarify something for me?
Sure.
And I understand your position here, but you're kind of characterizing him as some sort of innocent participant. I thought he was present when they drank and when they breathed or puffed. All four of them did that, didn't they?
Yes, exactly so. But there's no evidence that he induced her to fall into that. There were 4 young men present.
There's a finding by the district court that says all 4 men consumed the Bacardi and urged HD to drink also.
Right. That's what I want to get to. And
again, yes.
I understand your position.
I stand corrected with that. That's absolutely. But at the time this event took place in the room when there was sexual contact, I don't think there's any evidence that he handed her some liquor at that point.
No. I'm just talking about the environment that led to the activity. He was certainly a participant.
Yes, absolutely. No question about that.
At the very least, at least an observer of some of the activity, and then a participant.
Yes, that's right.
Okay.
To the extent he's culpable for that, I mean, it's true. But I think we have to separate that out a bit about the actual sexual contact itself.
I'm torn. I don't know how to reconcile this, so I'm just going to ask you to do it from your perspective. We have this notion that she said she was 16, And yet, the crime he pled to was for sex with a child, so we've got her under 16 for purposes of the crime that he pled to. And I don't know how to put those two facts together. I mean, or those two things together.
That is somewhat troubling. And the problem is, as to the contact and what she told him, my client, Mr. Punt, was that she was 16. Now, there was some other evidence that there were some young women that came through there and told one of the young men that you better get her out of there.
And I'm not trying to tag him for that.
No, I know you're
At
not.
this point, I'm still, this is what he pled to.
Yes.
And so what difference does it make, I guess, on the other? I'm just not sure how to reconcile, again, these two things.
I'm not sure I precisely.
The notion is he pled to a crime where the victim would have to be under 16.
Yes.
So does it make a difference that he sort of thought she was 16 at the time he committed the incident? It's a reverse of not wanting to let the pled crime create an alternate universe when we know what the facts were of the crime. You see what I'm getting at?
Yes. But I think in terms of the seriousness and whether or not it adds to the disproportional argument, I think is a different consideration. I know that he pled to solicitation, which is a level 8, and he has to plead or nolo contendere to those facts. And he certainly, at the time he pled, he knew that that was what he was pleading to. But the facts of the incident itself was there's no other information, no other evidence than the fact that he believed that she was 16. Now, does that make a huge difference in the analogy and in the argument that it was disproportional? I'm not certain of that. But I understand the troubling aspect of it. And I don't know how to add more than what I've done to help. Now, the problem that we have with this opinion from this panel is that in consideration of the first factor, they said, well, so far so good. I mean, here are the things that work in his favor. One of the major things that works in his favor is the fact that he didn't instigate it. He wasn't the aggressor at all. But then they say, within the context of the first factor, these things work against him. Sex is a serious crime. You have to consider the peniological value and the peniological system of rehabilitation, incapacitation, and all those kinds of things that attach themselves to that value. The problem that we have is that in the context of the facts, why does that weigh equally? When in fact, they've exceeded and conceded that he had a very minor participation in this, that all those facts that weighed heavily in his favor are counterbalanced and weighs equally with the other first factors. Well, if you say that a sex crime is serious, well, of course it is. Of course it is. But we also know that he's not a chronic sexual offender. He wasn't the aggressor. He doesn't have a history of violation of sexual crimes. Nothing in his background would lend itself to the fact that counterbalances the fact that a sex crime is important.
The other thing that's bothering me about this case is trying to be delicate about this on a family internet stream, but
it's not easy.
The nature of this offense being sort of simultaneous group sex, and I mean simultaneous.
Exactly.
To me adds a level of depravity to this. Do you disagree? I mean, what do you think about that?
Well, from a
Especially
think
when, then when
probably
you add the, and then we pled to a sex crime with a child.
Yeah. It certainly adds to the moral equivocation of what was done. But
Was there any testimony? My understanding was that the victim here initiated the contact that started with your client, and that then Mr. Mendoza decided to join in. Was there any indication that your client knew that was going to happen, or did anything to permit the actions of Mr. Mendoza? The way I read it was that was just something he did, and that the way I read the district court, she was ascribing no encouragement or request or whatever on the part of your client.
I think that's accurate. I don't know of any evidence that says he encouraged or knew or had prior knowledge. I think this was spontaneous acts, if I can use that term, by a bunch of 19-year-old kids overloaded with testosterone. But to answer your question directly, Justice Johnson, I think that your interpretation of what happened is correct. Now,
can I move you from, you're about out of time, and
Sure.
you've talked a great deal about the character of the defendant. Under that first factor, isn't it also appropriate to discuss the crime itself?
yes,
The character of the crime. The thing that bothers me is that the court sentenced this defendant to 18 months probation, and the underlying prison term was 10 months, and was 19 years old, and now for the rest of his life he's going to be deprived of full freedom on a crime that he got probation for.
yes.
Did you argue that to the district court?
I didn't represent. This was a plea.
Was that, yeah, okay, but
I didn't represent
there
him.
was a motion for, there was a hearing on this particular issue, was there
Yes.
not?
There was a very thorough motion filed by trial counsel. And if you read that motion, I think it pretty well lays out the point of what we're talking about here.
Let me go at it at a different basis. When we're looking at disproportionate, you've been talking so far about being disproportionate to the conduct. Is there a basis by which we could consider disproportionality with regard to the punishment the legislature has assigned to this crime?
Yes, exactly. And I
Do you
think
have
that,
some case law that would support that?
no,
part of it?
other than the Freeman case, which says that you are to judge this based, number one, on the facts, and then the comparison tests of 2 and 3. I think one of the problems that exists in this particular statute as applied individually to these facts, the parameters are so broad. First of all, here we have somebody that was dropped from a 3 to an 8. Now, I'm not saying that an 8 isn't serious, because it certainly is. But the primary problem and the key to this whole controversy, I think, is that the legislature chose to bundle anything that could be designated a sex crime, even those below a level 4, when you could argue that if you're going to put somebody on a lifetime post-release period, why don't you put it where it belongs, and that's in the upper register of crime. But I think if someone, as you designate, Justice Johnson, says that, like the court did in this case, and the court had some regrets. If you read Judge Cudney's journal entry, the court had some real regrets about what she had to do, but acknowledged the fact that the law spoke otherwise, and that's why we're here. It's our position that not only is it disproportionate of level 1, it's grossly disproportionate, and if that's true, then Freeman says that although each factor is to be treated equally and no one factor is to be predominant, so to speak, if one factor is so overwhelming and passes the threshold question of disproportionality, the other two factors are mitigated, for lack of a better term. And I guess I like to put this in a simple way, as you indicated that you would prefer in your dissent in Mossman, Justice Johnson, and that is, here are some, in fact, the Court of Appeals struggled to come up with any kind of analogous cases. Every case that they cited in their opinion was something considerably more serious, 2, 3, or I don't remember exactly what the levels were, but they were certainly much above a level 8. And they couldn't do it. And they had to admit, well, arguably, it wasn't the same as what we have suggested as analogous cases. So I think that's telling. Plus all of the facts that we all know are undisputed. And to take the peniological consideration of this factor and the serious nature of the crime consideration in the first factor, I just don't think that it overwhelms the other factors. And as the panel said, weighs evenly. There's no way that weighs evenly, given the consideration to these other factors. That's the basis of our argument.
When he pled, he was informed that this was going to be a lifetime post-release. And he was informed of that by the court, wasn't he? That was a condition of the,
Oh, sure.
of the plea. Okay.
Yes. Now, counterbalancing that, and I think I know where you're going with that, Justice Rosen, is the fact that he's facing a 3.
No, I understand. I understand the bargain that took place.
And that's a tough one.
No, I understand.
So I'm not sure he had a choice at that point, for sure.
Any more questions?
There's a number of defense lawyers, including myself, who would have taken serious consideration to trying that case. And I can't criticize trial counsel because you don't know what went into it.
Thank you, counsel.
Thank you.
May it please the court. I am Robert Walsh. I'm the county attorney in Cloud County. As we look at this case, I think it is important to understand the actions of the defendant in this case. He seems to be characterized as a victim in this matter, that he is the one that is being persecuted in this matter, but the facts belie that. He was involved in a plan, and that's really what it was, to get this underage child intoxicated. And the purpose of the intoxication was to dilute her will or her ability to defend or object what was going to happen to her. There really isn't any question that was what was going on here. This was a grooming, if you will, of this child. There was the alcohol involved.
Are there any finding by the district court that there was a grooming kind of scenario?
No, just the facts as they speak for themselves, and that the 4 men encouraged her to drink.
And the reason I ask that is because I'm looking right here at a quote from Judge Cudney. Mm-hmm. Quote, "The court notes, however, that the facts of this case clearly reflect the injustice of lifetime post-release supervision. An 18-year-old young man who allowed a 14-year-old girl to voluntarily perform oral sex upon him without request or force will suffer the consequences of these actions for the remainder of his adult life," end quote.
Sure.
That doesn't sound like to me that we have this conspiracy and plan, or at least the judge viewed it in that in that
Obviously,
nature.
certainly that's her opinion, but I think the facts speak differently to that by the way that this all took place. And I might add that even though she's under, even though there was what is characterized as consent on her part, or she was the aggressor, this is still a crime. It would still be a sodomy. And I don't think we can forget that, even though she was the one that was the aggressor.
I don't think we're forgetting that, and the conviction is not before us, but when does the post-relief or post-release period become disproportionate to the underlying sentence?
Well,
I mean, we've got 18 months.
If
This
you look
is
at
not
that-
so serious that this person doesn't even have to go to prison.
Right.
Leaves the courtroom and is on probation for 18 months, but I'm sorry, that probation is essentially going to extend for the rest of your adult life.
If I could address that in three different ways. First of all, we talked about what he was convicted of, but the crime was a sodomy. The crime was a level 3 sodomy in all practicality. He was given the benefit of the doubt by the plea negotiation. But by even his own admission and by all the facts that are uncontroverted, this was a sodomy with an underage child. The second point I'd like to make on that this post-release supervision is not a guarantee he's going to prison. I think we lose sight of that sometimes. It is a potential that he's going to prison, and he has to commit another felony, and he has to be convicted of another felony.
Can he go where he wants, when he wants, without telling anyone what to do, where he's going?
I don't believe that I don't know that for sure. I would guess that he cannot. But
So his freedom is not the same as every other citizen in the United States for the rest of his adult life, whether he violates or not. Would you agree with that?
I would, but conversely, he's not in prison also.
Well, he's not in prison, but he's not in North Korea either. He's in the United States of America.
And I guess I mentioned the third point, that these type of crimes involving children are seriously addressed by the legislature. This is not a property crime in which they have to be watched closely. This is a child, and this is a crime in which a child was the victim. And
I think we've addressed that. We've talked about the penological concerns and the rehabilitation and all of that, and we're trying to then look at, does the punishment fit the crime? Mm-hmm. And you have the same punishment with regard to post-release supervision as if this had been a horrendous, egregious offense against a baby. And is that proportional to the crime here? I mean, isn't that what we're looking at under freedom, proportionality?
And I agree with you. Yes, I do agree with you. And to be honest with you, and be candid with you, I am not a big proponent of the post-release, lifetime post-release supervision. But we have what we have. We have the legislature that have decided that this is the way it's going to be. And if we are looking at these in case-specific factual situations, then this case is not one in which there is a gross or significant disproportionality here. This was a serious sex offense. This was, for all practical purposes, a level 3 felony. This was involving a child. This was a case in which the defendant, though he is characterized as being completely innocent or less culpable, was culpable and did plan and did execute this plan.
And this might not really factor in anything, but what happened to his co-defendants?
The Mendoza, and this is from memory, so
I'm just curious.
He was convicted of a rape, and there was others that were convicted of sexual batteries. There were
Aggravated sexual battery? Were they
that I'm not sure of, though, because their participation was more of kissing and those type of things, and nothing more than that. And I believe it was aggravated, but I don't get quoted on that.
Were they were the aggravated sexual or the battery subject to lifetime post-release? Or
I don't know.
Okay.
I wish I could answer that, but I do not know. Well, unless there are any other questions, the state would respectfully request that the sentence be upheld as constitutional and not cruel and unusual.
I know this question's been asked before, but I'll let you have a chance to address it. when we look at proportional with respect to other crimes, you know, here if he'd had a sudden quarrel or heat of passion and actually killed this girl, he would have had 36 months of post-release supervision, 3 years. And now when you say this is a serious crime, wouldn't that be a serious crime of actually killing her? So, I mean, how do you
And that's the only
justify
argument I can
that
make.
disparity?
And I appreciate that, Justice Johnson, but
Yeah.
the only argument I can bring up with that is that it's well known that pedophiles or offenders against children are repeat offenders, and I don't know the history of why the legislature decided to make this such a serious crime, but it does come back to, I think, the possibility of recidivism on this, and I would guess, again, I'm just guessing on that, but I don't want to stand in the shoes of the legislature and tell you why they have made it. It is what it is, and this court has that before it.
Any more questions? Thank you, counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
Judge, I'm going to waive rebuttal. Thank you.
Any questions for counsel? I see none. Thank you both for your arguments this morning. Court will take this matter under advisement.